It's Conduit News Radio with Paul Harrell.
We've been teasing this all last hour, and we have to get to it. Yesterday in the Senate Public Health Committee, Senator Jason Rapert got his bill that would ban abortion in Arkansas unless the life of the mother is at risk, but only after Roe versus Wade is overturned, meaning if Roe versus Wade is reversed, which many people expect it to be, especially if Ruth Bader Ginsburg is the next justice to be replaced, then that would mean once that happens, Arkansas law goes into effect immediately. It's called an abortion trigger law. Other states have done it. Senator Jason Rapert doing an excellent job. Thankfully, because of the transparency effort, we have the audio and the video that we can share with you. And I'm going to play this for you because it was an incredible moment. It was filled with emotion. It was a long time coming. And that's an understatement when you think about the millions of babies that have been killed, the 3,000 or so babies that were killed last year in the state of Arkansas. This was a debate that needs to be had. This is really, folks, it is the issue of our time. And because this has never been done before on the scale that it's being done right now. 60 million plus babies since 1974. It is incredibly horrific. It is a genocide. And here it is. This is Senator Rapert presenting his bill yesterday in the Senate Public Health Committee, and the discussion ensued afterwards. Here he is.
Has a long history of legislation and a constitutional amendment even that advocates the protection of unborn human babies. The only thing that has prevented Arkansas from banning abortions altogether is the Roe v. Wade decision of 1973 and related decisions, which is often cited by federal courts when they strike down pro-life legislation around the country. Legal scholars now believe that with new judges being added to the U.S. Supreme Court, there is a very good chance that Roe v. Wade will soon be overturned and the authority of states to regulate and prohibit abortion in their own states will be restored. SB 149 is what has been termed a trigger law, meaning that when and if Roe v. Wade is overturned and the authority to regulate abortion is restored to the individual states, or a U.S. constitutional amendment were to be passed doing the same, that Arkansas would immediately prohibit abortion in our state except when necessary to save the life of a mother in a medical emergency. That exception is the standard of national right to life, and that's why that exception is in the bill. You'll see, if you want to draw your attention to the findings, upon discussion with some of the legal scholars, especially many of the scholars that have been a part of what you have seen out publicly called the moral outcry. The moral outcry is a petition-driven movement actually applying to the Supreme Court itself. And this is part of why I've got the findings here in the bill. And it's to illustrate that there's a grave injustice that's going on that is actually ignoring the most fundamental civil right that any of us have, which is the right to life. Over 60 million little babies in our country have been precluded from that simple, but yet the most humane right that we have, simply to be born. And what happened is over time, as the U.S. Supreme Court has actually made decisions that overturned some prior precedent when they realized there was a grave injustice. I bring your attention, it starts there on page 2 of your bill. It is time for the United States Supreme Court to redress and correct the grave injustice and the crime against humanity which is being perpetuated by their decisions in Roe, Doe, and Planned Parenthood versus Casey. The U.S. Supreme Court committed a grave injustice and a crime against humanity in the Dred Scott decision by denying personhood to a class of human beings, which was our fellow Americans who are African Americans. The United States Supreme Court also committed a grave injustice and a crime against humanity by upholding the separate but equal doctrine, Plessy versus Ferguson, which withdrew legal protection from a class of human beings who were persons under the U.S. Constitution, our fellow African Americans. A crime against humanity occurs when a government withdraws legal protection from a class of human beings, resulting in severe deprivation of their rights up to and including death. In Brown versus Board of Education, the U.S. Supreme Court corrected that grave injustice and crime against humanity created in Plessy versus Ferguson by overruling and abolishing a 58-year-old separate but equal doctrine, thus giving equal rights to African Americans. When you look at this, under the doctrine of stare decisis, the 3 abortion cases mentioned in the subdivisions above meet the test for when a case should be overturned by the United States Supreme Court because of significant changes in facts or laws, including without limitation the following. The cases have not been accepted by scholars, judges, and the American people, as witnessed by the fact that these cases are still the most intensely controversial cases in American history at the present time. New scientific advances have demonstrated since 1973 that life begins at the moment of conception, which, by the way, our Arkansas Constitution acknowledges that, and that was voted in by the people in Amendment 68. And also, the scientific evidence shows that a child in a woman's womb is a human being. Scientific evidence and personal testimonies document the massive harm that abortion causes to women. Just for the sake.
Okay, this is Senator Jason Rapert, and he's in the public health, doing an excellent job. But what he is saying here is so important. He's saying that over our history, no one likes to admit this because they like to think the Supreme Court is the end-all, be-all, and we don't have a say in anything. But what he's saying is throughout our history, the Supreme Court is wrong sometimes. Sometimes the Supreme Court in our history is inhumane, and they make decisions that are unconscionable today. He mentions Dred Scott, says you're not a person under the Constitution if you have black skin. And we have now we have this, the Democrats still the party of slavery in many regards because they're still in the business of deciding who is a person and who's not. I've made that point many times throughout the years. I'm so glad that Senator Rapert also has put that in his bill, saying, listen, and or you know, Plessy versus Ferguson, or Brown versus Board of Education, Dred Scott, all these things are the Supreme Court doing things that we now find to be morally reprehensible as a society. And abortion is the same thing, and it's in that category, and it will be in that category in the future. Go ahead, Joe. Continue with Senator Rapert's testimony.
Not being able to bring them, I have access to over 4,000 written testimonies that have been introduced in court cases across this land from ladies that have actually had abortions themselves and suffered the trauma that comes additionally after having that procedure. The laws in all 50 states have now changed through safe haven laws to eliminate all burden of child care from women who do not want to care for a child. Your committee just did a wonderful thing a few days ago when you allowed the safe haven law to be upgraded here to include boxes where we could actually receive those children safely. And I think Senator Hickey had an amendment to that to make sure that they're properly monitored. Public attitudes favoring adoption have created a culture of adoption in the United States, with many families waiting long periods of time to adopt newborn infants. Before the U.S. Supreme Court decision in Roe v. Wade, Arkansas had already enacted prohibitions on abortions under sections that are quoted here in the findings for you. Arkansas Constitution Amendment 68 states the policy of Arkansas is to protect the life of every unborn child from conception until birth, and that public funds shall not be used to pay for any abortion except to save the life of the mother. Arkansas passed the Arkansas Heartbeat Protection Act. 6 years ago, in this very room, was where the Heartbeat Protection Act started. When we did that and passed that act, it actually obviously had the 12-week ban struck down by a federal court. But what was left in place with that was the informed consent provisions. And I've had a discussion with several members about my experience with that. In the state of Arkansas, right now, due to our informed consent provisions, we're saving lives, but we're not saving all lives. And what I'm asking you to do in SB 149 is at the very moment we get authority, we will save lives. I've had a couple people bring up the exception issue. I understand that. These are serious issues. But I will tell you that my own experience has brought me to understand that I can't arbitrarily draw a line. I was in a restaurant in Conway, Arkansas about 2 years ago. I finished with my family, Mr. Chairman, and saw a lady coming across the floor pushing a stroller, hurriedly across the floor. She approached me and my family, and she stated to me that she wanted to meet me and was appreciative that I'd stop for a moment. And I greeted her, and she says, "I want to introduce you to Duncan." I look down on the stroller, and I see a little boy about 6 months old. He's sucking on a pacifier, had a little bow tie on. I said, "Well, he's a cute little guy." And then when I looked at her, she caught my eye again. She said, "Sir, he's alive because of your heartbeat bill." With that, I really didn't have words. And it's been a while that I could tell this story and actually get it without choking up a bit. I said, "Ma'am, you'll have to explain it to me." I said, "First of all, it's not my bill. The Arkansas legislature of 2013 passed that bill, and they're the ones that are really responsible. This is a law for the state of Arkansas." She said, "Well, let me explain to you." She said, "I'm the adopted mother. Duncan's mother was raped, and she took the morning after pill. It didn't work. That was Duncan's first survival. She then appeared at the abortion clinic down the road from where we sit here, just 10 or 15 minutes. She was prepping for her abortion. They performed the ultrasound, which the Heartbeat Protection Act does require, and they detected a heartbeat. And they told her of the statistical probability that her baby would actually make it to full term. With that knowledge, she said, "I can't do this," and I put the baby up for adoption. Told me that story. I thanked her for that. It's the first time I'd ever seen someone that told me that. And absolutely, members, what you do here absolutely has changed lives in that particular situation, and it's changed lives in other situations. So when you look at the history of what Arkansas has done, we passed Amendment 68. We even passed here, after the heartbeat bill, Senator Jim Hendren ran a bill which changed our fetal homicide law. We used to only recognize it at 12 weeks that there was the infant's life. Now, the infant fetal homicide law in Arkansas recognizes that from the moment of conception, in a mother's womb. So what you see is time and time and time again here in Arkansas, we have stood up for the rights of unborn children, of human life in a mother's womb. To bring this to a point on this bill, 4 other states currently have in place legislation that would ban abortion in their states if and when Roe v. Wade is overturned. That's North Dakota, South Dakota, Mississippi, and Louisiana. These are commonly referred, as I said, as these abortion trigger laws. The state of New York recently expanded abortion policy. You heard that mentioned last night in the president's address. In their state, they now allow abortions to be performed right up until the time of birth in certain situations. One of the stated reasons that New York took, which really took me off of my feet the day that they signed their bill, was the day I filed this bill. And they stated that New York took this step with the anticipation of a possible overturn decision of Roe by the U.S. Supreme Court in the near future. Vermont is also pursuing legislation that further expands abortion policy in their state. The state of Arkansas is clearly a pro-life state. Our citizens, our legislature have spoken clearly time and time again, and we should and must protect the lives of innocent unborn babies. The law clearly allows Arkansas to take steps right now to prohibit abortion in our state if and when our authority to regulate or prohibit abortion is restored. SB 149 establishes the will of the people of this state. If we are fortunate enough to have the U.S. Supreme Court make a decision that would return the authority, all 135 legislators are being given an opportunity to clearly articulate the humanity of human beings and voice our will to protect and honor human life by passing this bill. As President Donald Trump said last night, after calling out the offensive expansion of abortion in New York and comments made by Virginia Governor Northam, and also even calling for Congress to ban late-term abortions himself, he said this, and this closes it for me, and it's where I stand. Let us reaffirm a fundamental truth that all children, born and unborn, are made in the holy image of God. Members, I ask you to vote for SB 149, the Arkansas Human Life Protection Amendment, and make sure that we have the will of the people ready at the very moment that we're given the authority to ban abortion in our state. Thank you, sir.
Thank you, sir.
Stop. All right.
Are there any
Jason,
questions from
Jason, that was entire presentation yesterday before the House or the Senate Public Health Committee. It did pass. It passed out with an overwhelming voice vote. There was no votes. There was no dissenting votes. And it was just incredible. You know, I want to say something here. We're going to take a break and come back and listen to a little bit more of the questions. But I want to say, in light of the fact New York State is doing what they're doing and the state of Virginia is doing what they're doing this in preparation for Roe versus Wade being overturned. Arkansas is doing this in preparation for Roe versus Wade being overturned. But we're taking two completely opposite paths. And I'm so thankful right now that I live in Arkansas instead of New York or Virginia. So afterward, after Senator Rapert got through with his bill, it was a good day yesterday at the Arkansas legislature. This was one of the biggest reasons why, because his bill, his pro-life bill, passed out of this committee. There was some discussion about rape, because there is in the bill an exception for an abortion if the life of the mother is at risk. Again, he said that is the national right to life standard. But then, of course, you have, well, what about rape? Well, it was brought out, it was painfully brought out eventually, that the law only applies when you can detect medically that a pregnancy has happened, which is like 3 weeks. And so because of that, so-called contraceptives like Plan B or chemical abortions, things like that, the drugs or chemicals, that, you know, if somebody were to be raped and they go to the hospital, this would not preclude them from being able to use those types of methods to make sure pregnancy doesn't happen. And eventually it came up that those drugs are only able to work within 5 days of a sexual encounter. So just so you know, I mean, and is that a perfect situation? Are there people that may not get there within 5 days? Absolutely. But there was what it was said in the committee, 3,000 babies in Arkansas killed last year for with abortion. You know what? Let's just get to the questions right after his testimony. We don't have a lot of time. We got about 5 more minutes of this. Let's go ahead and click play, Joe, right there, and let's get to, I think, is it Senator Caldwell that had the first question? Go ahead whenever you're ready, Joe.
Thank you, Mr. Chair. I want to point out one thing, Senator Rapert. I know there's been a lot of discussion about not having the exemption for rape and incest in here, but I do want to point out on page 4, beginning on line 31, it says, this section does not prohibit the sale, use, prescription, administration of a contraceptive measure, drug, or chemical if the contraceptive measure, drug, or chemical is administered before the time when a pregnancy could be determined through conventional medical testing. Basically, that means that if you had rape or incest and you knew it immediately and were treated at a hospital, that you could be treated with some chemical or device to prevent a pregnancy from occurring. Is that correct?
If that's allowable under the language,
Yep.
Yes, sir.
So, I mean, if you did have now, if that rape or incest occurred or was detected 6 months down the road, obviously there's no provision for.
Well, there would be no exception. I think
that's correct. We agree on that. But for so many of us, me included, if a rape occurred on Friday night, reported on Saturday, then there would be some measure to try to prevent pregnancy from occurring, based on this language I just read.
Well, and I'm going to try to make sure I'm looking at the same language. Tell me which line you're looking so that we don't get a confusion here.
Okay, page 4. You start on line 31. This section does not, and then you jump to line 34. It does not prohibit the sale, use, prescription, or administration of a contraceptive measure, drug, or chemical if the contraceptive measure, drug, or chemical is administered before the time when a pregnancy could be determined through conventional medical testing, which means if you were raped on Friday night, you could not determine that you were pregnant on Saturday, so they could use medical efforts to prevent a pregnancy.
Based on that language, I would say you're right on that assessment, sir.
There you go. There you go. There you go. There you go. So not only what we kind of brought out, not only is there an exception in case the life of the mother, but there's technically is still an exemption for rape. Now the window is smaller, but there's still an exemption for it. So I just want you to understand something. This bill in Arkansas, the people who are leftists in Arkansas are the ones still on a sinking ship, and they're crazy. Let me just be perfectly clear with you. They're nuts. They're crazy. That's Republican Senator Ron Caldwell asking a great question. And what he did was bring out, essentially, some ammunition to use against what the left is going to say, which is that you don't care about women and blah, 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 whatever. The fact of the matter is the bill has a written exemption in case the life of the mother. And in the case of rape, again, it's not going to get, I mean, not every rape, I'm sure, is going to be reported within 5 days. But at some point, you have to understand that this is about stopping genocide and saving lives. And Roe versus Wade, the societal consequences are, I guarantee you, the judges had no idea what it was going to be as bad as it is.